I'm still pouring through trial 1.0 and motions for trial 2.0 are getting denied hell west and crooked. But for all the reasons given in the last video, I'm not going to stress about trial 2.0. I'm going to focus on the 1.0 content because I do suspect a stay from the federal court. Anyway, this is just some stray stuff that didn't fit with the other topics. Someone asked in the comments, can we see how you put your workflow together? No. There's absolutely no rhyme or reason. I just try to group the information together as I come across it. And that way it looks at least half cohesive at your end. One of the things I was trying to find was the legal basis for Judge Cannoni refusing to allow grounds for objections to be spoken aloud during trial. Andrea Burkhart had briefly spoken about this on Alita's channel, Legal Bites. I think it was around day 2 of trial, and it was only a paragraph to explain in appellate terms what she thought Bev was up to. So I want to dig into it more today, find some layman terms to explain it, and find out a little bit more about other reasons Bev might be doing it. So first of all, it is improper for Judge Cannoni to prevent grounds for objections from being spoken aloud during trial. The reason it's improper is because it directly interferes with the defendant's constitutional rights with specific regard to the ability to preserve issues for appeal. And that is essentially what Andrea explained in a bit broader terms. But we're going to break it down into layman, non-appellate terms. So for those who don't understand what grounds for objection means, it's when the attorney says, objection, relevance. For example, they use the word objection to let the judge know that they have an objection, and then generally 1 or 2 words that follow it to state the grounds for that objection. Less experienced lawyers might call objection and then start an argument, for example, and that would be improper. But in the Karen Reid case, we're dealing with very experienced trial lawyers, and they're not likely to be improper. So that's not the reason that Judge Bev has decided to bar its use in her court. Nonetheless, with the Habeas petition, it does raise some key legal concerns. 1. Due process violation, 5th and 14th Amendments, preventing objections from being fully articulated may deprive the defence of a fair trial. 2. Violation of the right to a meaningful appeal, which is again the 6th and 14th Amendments. If objections are not properly recorded, appellate courts cannot review them, effectively stripping the defendant of their right to an appeal. And then number 3, contrary to established trial procedure and case law. Objections must be on the record to be preserved for post-trial motions and appeals. So let's break all this down so that we can understand it. Why is it improper? Firstly, because objections must be on the record to preserve the constitutional violations for appeal. In the case of the Habeas petition, it's very difficult for them to pull up transcripts and say, look, here's where the judge said blah blah, because the judge isn't really saying anything other than, I'll allow it. And she's certainly not letting the objectioner state their grounds. The right to a fair trial includes the ability to challenge improper evidence, arguments, and rulings. So when a judge prevents objections from being spoken aloud and placed on the record, they effectively shield improper rulings from appellate review. Or said more bluntly, she's shielding herself from appellate review. This falls under Griffin v. Illinois, 1956. Defendants must have adequate record for appellate review. A trial judge cannot obstruct the creation of that record. And Wardius v. Oregon, 1973, a trial procedure that unfairly disadvantages the defence violates due process. This case law supports the idea that Judge Cannoni's refusal to allow objections directly prevents the defence from making a clear record of trial errors, and without an objection on the record, appellate courts may refuse to consider certain claims, making the trial court's rulings unchallengeable. Important to note, that whilst it is often said that everyone's entitled to an appeal, that doesn't mean everybody's going to get an appeal. And that's because the appeals court only deals with issues where the trial judge has made an error in the application of the law. You need to state the particular law that the judge ruled on that was in error. So from the outset, when the appeals court looks at it, they need to clearly see that law is the one at issue, and here's how the judge ruled on it. And if the judge's ruling is in line with that law, they will dismiss it outright. So yes, while everyone's technically entitled to an appeal, not everyone will have a valid claim with regards to application of law. So in addition to obstructing your ability to make a valid claim in the appeals court, it's also interfering with the right to a meaningful defence. Defence counsel must be able to contemporaneously object to issues that infringe on the defendant's rights. If a judge forces objections to be whispered, written or omitted altogether, it prevents the defence from making a full and proper record. By record, we're talking about the transcription of the trial proceedings. Herring v. New York, 1975, is the case law that establishes trial judges have discretion, but they cannot deprive the defence of fundamental advocacy rights. So if Judge Cannoni's ruling prevents the defence from fully articulating objections, she's interfering with the defence's right to present a case and challenge prosecutorial misconduct. So regarding the court transcriptions, federal law requires that trial records must be sufficient for appeal. Case law Everts v. Lucy, 1985, establishes a defendant has a right to an effective appeal, and an incomplete or manipulated record undermines that right. Also, under Federal Rules of Evidence 103, it says to preserve an objection for appeal, it must be on the record stating the grounds. Hence, if Judge Cannoni prevents objections from being spoken aloud, she is actively obstructing the defence from creating an appealable record. This means that appellate courts may not consider key issues on review, effectively shielding trial errors from scrutiny. Moreover, it violates Massachusetts and federal courtroom procedures. Judges have discretion over courtroom proceedings, but they cannot eliminate the requirement that objections be stated on the record. Taylor v. Illinois, 1988, establishes judicial discretion cannot be used to restrict a defendant's ability to make a record for appellate review. Massachusetts Rule of Civil Law 46 states, an objection must be stated clearly at the time of the ruling to be preserved for appeal. By prohibiting objections from being stated aloud, Judge Cannoni is undermining procedural fairness and appellate rights. Even if the objections are made through written notes or sidebars, this is insufficient if it prevents the defence from fully articulating the grounds for appeal. As with all the due process issues we've raised to date, this one is also relevant to the Habeas petition. The inability to properly object on the record will be one of the strongest arguments for habeas relief. Wainwright v. Sykes, 1977, says a defendant cannot be penalised for failing to make objections if the trial court actively prevented them from doing so. Strickland v. Washington, 1984, says a trial that systematically prevents a defendant from raising legal objections is fundamentally unfair. If the federal court finds that Judge Cannoni obstructed the defence's ability to object, it may grant habeas relief. This issue strengthens the cumulative due process violations already identified in the habeas petition. Under Chambers v. Mississippi, 1973, it says that a trial that prevents the defence from presenting its case fairly is unconstitutional. So, to wrap up what we just learned, Judge Cannoni's rule is improper and violates due process. The key takeaways are: preventing oral objections is highly improper because it obstructs the ability to create an appealable record. It violates the defendant's right to due process, appellate review, and a meaningful defence. And Judge Canoni's practice of preventing objections from being stated aloud adds to the cumulative due process violations that warrant federal habeas relief. So people ask all the time, how the heck is she getting away with this crap? And the unfortunate answer is that only certain people with millions to burn can make it to this level of appeal. If you want to go up to SCOTUS level, you're talking millions more. So if we're talking only 1 or 2% of the cases that Judge Bev tries, then there's your answer. She gets away with it because hardly anyone can get to that level, so she doesn't really have a very long record. And just like Jan, she probably comes up with some really good excuses. So this is what I looked into next. What kind of excuses could she use to get away with isolated cases where something like preventing objections makes it to the appeals court? And I did find a few, though none would outweigh the constitutional concerns that this practice raises. If Judge Canoni could claim that allowing objections to be stated aloud in front of the jury may improperly influence the jury's perception of the evidence or proceedings, or that objections can act as mini-arguments that expose the jury to inadmissible evidence or improper legal disputes, neither arguments would justify her ban. Objections are normally part of trial advocacy, and juries are routinely instructed to disregard arguments that they are not meant to consider. Judges can instruct the jury to disregard objections if necessary, rather than prevent them from being stated at all. And Massachusetts federal and state courts have no established rule requiring objections to be muted or suppressed. Under case law Lakeside v. Oregon 1978, it says juries are presumed to follow judicial instructions, meaning a properly given instruction would cure any alleged prejudice. Personally, I think these two are garbage excuses, but for the sake of argument, we will include them. The judge might argue that allowing objections to be spoken aloud slows down proceedings, particularly if attorneys are making frequent or extended objections. She may claim that having objections submitted in writing or raised during sidebars keeps the trial moving smoothly. However, efficiency does not override due process rights. Courts have ruled that procedural expediency cannot come at the expense of a defendant's ability to object and make a record. Written objections or forced sidebars prevent spontaneous responses to improperly admitted evidence, which is often time sensitive. Every other trial court in the US allows oral objections because efficiency is not an excuse for denying fundamental rights. This falls under case law Herring v. New York, 1975. Where it says judicial efficiency cannot justify limiting a defence's ability to participate in trial proceedings. Additionally, Judge Canoni may claim that some attorneys use objections as a way to argue points before the jury, rather than as a legitimate evidentiary challenge. She may argue that objections should be stated minimally, for example, objection hearsay, without explanation to avoid improper advocacy. However, attorneys are already trained to make proper objections and not abuse them for advocacy. If an attorney does this improperly, the judge can't overrule the objection or warn counsel. And we've already established that Karen's team are very experienced trial lawyers. They're not likely to make this mistake. Simply making an objection does not improperly sway the jury. In fact, it ensures fairness in how evidence is presented. A blanket prohibition on stating the basis of an objection strips the defense of the ability to protect the record for appeal. Under United States v. Young, 1985, it says, improper argument can be addressed with judicial discretion. It does not justify preventing proper objections. It wouldn't surprise me one bit if Judge Bev was like accustomed to Lally's monotone voice, and that Yannetti and Jackson's high-speed, high-paced, energetic approaches, likely reminiscent of the city, is all too much for her. So out of everything, I reckon this is probably the most likely excuse she would pull. She'd probably say that the trial has become contentious, or the attorneys are making frequent or loud objections, and she's only doing it to maintain decorum. Or she could claim that too many objections creates an adversarial atmosphere that affects the jury's perception of the case. But it just doesn't cut it, because judges already have the power to control disruptive conduct through traditional methods, sustaining, overruling, issuing warnings, etc. Preventing the defence from speaking objections aloud punishes them unfairly, even if the prosecutor is making improper arguments. And silencing objections disproportionately benefits the state, because the defence is typically the party objecting to state-presented evidence. We've all seen that over and over again. Would you like to object, Mr. Lally? As if that doesn't benefit the state. In Illinois v. Allen, 1970, it says a judge can control courtroom behaviour but cannot infringe on a defendant's right to participate in their defence. And then finally, the original reason that we just covered way back at the start, she simply wants to avoid objections being preserved on the record. This is the most likely reason, though she won't admit it, because she knows that every objection stated aloud is transcribed into the trial record. And by forcing objections to be skipped entirely, she makes it harder for the defence to challenge her rulings on appeal. Because when objections are not on the record, appellate courts will have a harder time reviewing trial errors. And it is a serious due process violation. It directly obstructs appellate review, which is a constitutional right. It suggests intentional judicial misconduct, that she's actively working to prevent her rulings from being scrutinised. And if this is the true reason, it should be included in the Habeas petition as evidence of a trial court acting to conceal its own errors. Under Everts v. Lucy, 1985, it says, a defendant has a constitutional right to a meaningful appeal, and preventing objections from being recorded interferes with that right. Under Bracey v. Gramley, 1997, it says judicial bias and conduct that undermines fairness are valid bases for habeas relief. So essentially it looks like there is plenty of federal law to support the argument that there is no valid justification for preventing objections from being stated on the record. None of the potential justifications outweigh the constitutional harm of suppressing objections. And that's because judges already have the authority to instruct the jury, control improper arguments, warning counsel, and generally controlling the courtroom. So our final takeaways are, Judge Cannoni has no legitimate reason to prevent objections from being spoken aloud. This practice directly interferes with the defendant's right to a fair trial and a meaningful appeal. This should be explicitly raised in the habeas petition as a form of judicial misconduct and due process violation. On that note, some of you have asked, when is the appropriate time to add all of these additional due process violations to the habeas petition? As I said in the last video, there may be a strategic reason that Mr. Weinberg has limited everything down to just that one issue. But outside of strategy, there is a process, and I'm going to make that the subject of the next video. So stay tuned.